3 prior convictions in sequence, controlled substance, and evading arrest or detention with a motor vehicle. So you're looking at 25 to life on that. Unlawful possession of a firearm by a felon on April 18th of 2023, the same date as this earlier one.
Standing, this is the first time that Mr. McCain has been before the court on asking for a bond reduction. And he's been there for over 3 years.
He was arrested June 22nd, 2023.
Of committing a murder. And in each of these 3 cases, he's classified as an habitual felon. He's finally arrested on
June 22nd.
He said that was for the murder. He was arrested June
22nd. Well, finally arrested on something.
Well,
On June 22nd of that year. It's a murder.
Well, Your Honor,
Is that right? Is that right?
That's what he is alleged to have done. Yes.
Okay. The grand jury decided that he did that. And apparently the authorities. Okay. What's his bond?
$1 million on the murder, 50,000 on the other 2.
Fine.
Before we step inside this courtroom, take a moment to understand just how high the stakes are. This isn't a routine bond hearing. The defendant is facing allegations that, if proven, could keep him behind bars for the rest of his life. On top of that, prosecutors say he's a habitual felony offender, a designation that can dramatically increase potential penalties because of prior convictions. But this hearing isn't about deciding guilt or innocence. It's about one critical question. Should someone accused of crimes this serious remain behind bars while waiting for trial, or should they be given another chance at release under strict conditions? As the hearing unfolds, you'll hear the judge examine not only the current charges, but also the defendant's criminal history, the timeline of events, and whether public safety outweighs the constitutional presumption of innocence. One of the biggest twists comes when the court learns that the defendant allegedly committed a murder only weeks after bonding out on earlier felony charges. That single detail changes the entire tone of the hearing and becomes a major factor in the judge's reasoning. You'll also notice another issue that raises eyebrows inside the courtroom. A delay of nearly 3 years before the defense finally gets to argue for a bond reduction. Is that simply the reality of a complicated criminal case involving digital evidence? Or does it raise legitimate concerns about the pace of justice? The judge himself appears surprised by how long the case has been sitting without this motion being heard. Pay close attention to how each side frames its argument. The defense emphasizes constitutional rights, the difficulty of preparing a case from jail, and the principle that every defendant is presumed innocent until proven guilty. Meanwhile, the prosecution focuses on public safety, prior criminal history, and the allegation that another violent crime occurred while the defendant was already out on bond. Those competing arguments are exactly what makes hearings like this so important. As you watch, ask yourself this. If you were the judge, would protecting the community outweigh the defendant's right to pretrial release, or would you have reached a different conclusion? Stay until the end because the judge's ruling and the reasoning behind it could surprise you.
All right. You are Jamal McCain? Yes, sir. Okay. You were here with Ms. Barroso, your attorney and the state's attorney.
Yes, sir.
You're charged with 3 habitual felony crimes.
Yes, correct.
So you're looking at 3 times 25 years to life imprisonment, 3 times that. In 23 CR 795, third-degree felony of tampering or fabricating with evidence. You have 3 prior convictions in sequence, controlled substance, and evading arrest or detention with a motor vehicle. So you're looking at 25 to life on that. Unlawful possession of a firearm by a felon on April 18th of 2023, the same date as this earlier one. And the allegations are similar with the prior convictions. You're a habitual felon on that one. What's the date he was arrested on these 2? Anybody know?
I'm not sure, but I do know that he's been incarcerated for 3 years as of June, sometime first week of June, 4th, 5th.
Well, how long have you been representing?
Well, I was appointed in February. I'm his third attorney. His last attorney was Ryan Matuska, who we all understand has gone over to the federal.
I didn't know that.
Oh, I thought you were aware of that. Sorry.
No,
So he,
don't necessarily tell me.
two previous attorneys that withdrew. I'm his third, I'm his second appointed attorney. I believe the first one was hired, which was Marcus Wilkerson. He ended up withdrawing. Mr. Matuska was appointed. He ended up withdrawing, and then I was appointed. And from my understanding, this is the first time that Mr. McCain has been before the court on asking for a bond reduction. And he's been there for over 3 years.
He was arrested June 22nd, 2023.
All right. So he's charged with those two. Then thereafter, before he was arrested, a few months later, a couple months later, he's charged with a
It was a
murder.
couple weeks.
This says April 18th.
I stand corrected.
April 18th and then June 6th, which would be April and May, June. So I'm thinking about 6 weeks or 7 weeks later, he's accused of committing a murder. And in each of these three cases, he's classified as an habitual felon. He's finally arrested on
June 22nd.
He said that was for the murder. He was arrested June.
June 22nd. Well, finally arrested on something
Well,
on June 22nd of that year.
May 21st of 2023 on the tampering and the unlawful possession, and he bonded out on May 24th of 2023. And then he was
That is,
arrested.
you know what? Okay, I was curious about that because that's not in here anywhere in any of this. I swear, it's not. I don't have a 23. So hold on. So he commits two crimes. On now, habitual felon. He gets arrested, puts himself out, and then goes right out and commits a murder.
Well, Your Honor, it's
Is that right?
alleged.
Is that right?
That's what he is alleged to have done. Yes.
Okay. The grand jury decided that he did that,
Understand.
and apparently the authorities. Okay. What's his bond?
Of 1 million on the murder, 50,000 on the other two.
This is the moment where the hearing takes a dramatic turn. Notice how the discussion shifts away from simply looking at bond amounts and starts focusing on the sequence of events. According to the allegations presented in court, the defendant was arrested on felony charges, posted bond, and then only weeks later was accused of committing murder. Whether those allegations are ultimately proven at trial is a separate question entirely, but for bond purposes, judges are required to consider potential risks to public safety alongside the likelihood that a defendant will return to court. The judge's questions show exactly what he's trying to determine. Was this simply a defendant exercising his right to bond? Or does the timeline suggest a pattern that makes release too dangerous? These are the kinds of facts that often carry enormous weight during bond hearings. What do you think? Should allegations alone influence a judge's decision this heavily? Or should the presumption of innocence carry greater weight before trial? Let us know your thoughts in the comments because this balance between individual rights and community safety is one of the most debated issues in criminal justice.
The
What
bond was
else?
still good on the other two.
Okay.
I'm sorry.
The bond was still good on the other two. They're still open bonds.
Okay. It's $1 million is the
What
main
else do
one
you
that
want to
we're
add?
concerned about.
What else do you want to add?
Well, Your Honor, we would ask that Mr. McCain, if the court were so kind to reduce his bond at all, from the current amount of $1 million to whatever it feels is reasonable, that he be ordered to wear a GPS tracking device, that there be some strict conditions setting the bond. There's been no evidence that he's not going to appear for future court dates.
What about the evidence that he might be a danger to the community?
So let me just address the evidence, Your Honor, in the murder case. So there is a lot of digital evidence involved in this case. It's going to take a lot of time to review. We may have to end up hiring our own forensic expert.
Okay, what's stopping
Anyway,
you
it's
from doing
going
that?
to, well, Your Honor, it's becoming, it's a challenge to prepare a defense with Mr. McCain in jail. And I believe that he is entitled to a reasonable bond. He's innocent until proven guilty.
Unless proven guilty.
Unless proven guilty. But this offense is an alleged offense. He hasn't been convicted. He's been in jail for 3 years, and this is his first time appearing in court on a motion for a bond reduction. So I would.
That's terrible. That's a long delay.
Consideration.
That's shameful.
Yes, sir.
I don't know what happened on.
The defense has now presented its central argument, and it's an important one from a legal standpoint. They're not arguing that the charges should disappear today. Instead, they're arguing that keeping someone incarcerated for roughly 3 years before trial makes it extremely difficult to prepare an effective defense. Reviewing digital evidence, consulting forensic experts, and meeting with attorneys all become significantly more complicated when a defendant remains in custody. The judge even acknowledges that the delay appears unusually long, which suggests the court recognizes how serious prolonged pretrial detention can become. But at the same time, constitutional rights are only one side of the equation. Judges must also evaluate the seriousness of the charges, the defendant's criminal history, and whether releasing the individual could create a danger to the public. That's exactly why these hearings are often so difficult. Both sides are relying on legitimate legal principles that sometimes point in opposite directions.
This, but I'm glad you're in the ball game because you move things along.
Thank you.
State.
Yeah, we think the bond is sufficient due to the fact he was out on a felony, commits another felony. And we do have a little bit more than what she's saying as far as evidence is concerned.
The court finds that the bond is reasonable under these circumstances. These are extraordinarily serious, severe circumstances. He was arrested, charged with serious criminal felonies, and then thereafter is released on bond and commits murder in a few weeks. And the court finds this bond to be reasonable under these circumstances.
And here comes the ruling that ultimately defines this hearing. After weighing everything presented, the judge concludes that the existing bond should remain exactly where it is. Notice the reasoning. The decision isn't based solely on the severity of the murder charge. The judge repeatedly emphasizes the allegation that another serious offense occurred after the defendant had already been released on bond in earlier felony cases. From the court's perspective, that history significantly increases concerns about community safety. At the same time, the judge also recognizes that justice shouldn't be delayed indefinitely. That's why, instead of reducing bond, he pushes to move the murder trial forward as quickly as possible. In other words, the court declines to change the release conditions, but also wants the case resolved without unnecessary delay. It's a reminder that bond hearings are often less about deciding innocence and more about balancing constitutional protections against public safety concerns.
Set it for trial.
Yes, sir.
Okay. Try to fast track this, please.
Yes, sir.
I'm not asking you, I'm asking her.
I think we're set for trial in September already.
Okay.
We probably already have trial.
Put that, I'd like that to be prioritized as number one. Mr. Laird, if you're going to be handling that, it's set for September.
Yes, sir.
That murder case, let's try that first. Thank you.
This hearing illustrates just how complicated the criminal justice system can be. On one side, the defense argued that the defendant has spent approximately 3 years in jail awaiting trial, making it difficult to prepare an effective defense while reminding the court that every accused person is presumed innocent unless and until proven guilty. On the other side, prosecutors emphasized the seriousness of the allegations, the defendant's prior criminal history, and the claim that another violent felony was committed after he had already been released on bond. After considering both positions, the judge ruled that the existing bond would remain in place, finding it reasonable under the circumstances presented. However, the court also stressed that the case should move to trial as quickly as possible so the evidence can be fully examined and the allegations resolved through the judicial process. As always, it's important to remember that allegations discussed during a bond hearing are not findings of guilt, and the ultimate determination will be made at trial based on the evidence presented. Now we want to hear from you. Did the judge strike the right balance between protecting the community and preserving the defendant's constitutional rights? Or would you have ruled differently? If you found this courtroom breakdown informative, make sure to hit that like button, share your thoughts in the comments, share this video with others who enjoy real courtroom analysis, and subscribe for more in-depth legal breakdowns and jaw-dropping courtroom moments.